Something just changed in Washington that could directly affect how much you pay to stay in this country legally. And if you're waiting on a green card, a work permit, a visa renewal, or any immigration benefit from USCIS, you need to watch this video before you file anything. Because starting in April 2026, the price of nearly every immigration application is going up. And in some cases, it's going up dramatically. We're talking about fee increases that in certain categories exceed 100%. Not a typo, not an exaggeration, double. And if you file after the effective date without understanding the new fee schedule, your application could be rejected outright, not because of anything wrong with your case, but because you submitted the wrong check. So stay with me because the next 12 minutes could save you hundreds, possibly thousands of dollars and prevent a potentially catastrophic delay in your immigration case. Welcome to USA Move Guide, the channel committed to giving you clear, accurate, and unbiased immigration analysis grounded in real policy, real law, and real federal developments. We don't speculate. We don't sensationalize. Everything you hear in this video is based on official USCIS regulatory filings, the Federal Register, and established immigration law under the Immigration and Nationality Act. If you're new here, subscribe right now because what's happening to immigration fees in 2026 is one of the most significant administrative changes to the USCIS fee structure in nearly a decade, and it touches almost everyone in the immigration system. So, let's start at the beginning. What exactly happened and how did we get here? USCIS, the United States Citizenship and Immigration Services, is what's known as a fee-funded agency. Unlike most federal agencies, it does not receive a direct annual appropriation from Congress to fund its day-to-day operations. Instead, it relies almost entirely on the filing fees you and millions of other applicants pay every single year to process applications, conduct interviews, run background checks, and adjudicate petitions. That structure has been in place for decades, and for years, immigration attorneys and policy analysts, including those who advised members of Congress on appropriations and immigration oversight, have warned that the fee structure was becoming dangerously underfunded relative to USCIS's actual operating costs. The agency has been running a structural deficit. Backlogs have exploded. Processing times in certain categories have stretched to 2, 3, even for years. USCIS has repeatedly flagged in its actuarial analysis that its fees were not keeping pace with inflation, staffing costs, technology infrastructure, and adjudication complexity. And so consistent with its rulemaking authority under the Administrative Procedure Act and its statutory mandate under the INA, specifically under sections of Title VIII of the United States Code. USCIS conducted a comprehensive fee review and published a final rule adjusting the fee schedule. This is where things become critical. This is not a bill that passed Congress last week. This is not a legislative battle still being fought on the Senate floor. This is a finalized federal regulation, a rule that has already completed the notice and comment rulemaking process, has been published in the Federal Register, and carries the full force of federal law. The fee increases are not proposed. They are not pending. They are coming, and the effective date for many of these new fees falls in 2026. So, let's talk specifically about what you're going to pay. The new USCIS fee schedule affects virtually every major immigration benefit category. Let me walk you through the numbers that matter most. And I want you to listen carefully because some of these increases are going to surprise you. For the Form I-485, that's the application to register permanent residence, the green card application. The new fee for applicants between the ages of 14 and 78 is increasing significantly from the current $610 for employment-based and family-based green card applicants. The combined filing fee, including biometrics, which under the new rule is now bundled into the application fee rather than billed separately, brings the total cost meaningfully higher. In some employment-based categories, applicants and their employers will be looking at fees that have effectively increased by 40 to 70% when you account for the restructured billing. For the Form I-30, that's the petition for alien relative, the foundational petition that kicks off the family-based immigration process. The fee is increasing for the Form I-140, the immigrant petition for alien workers. The fee is going up as well for asylum seekers. This new rule introduces something that has never existed in the history of modern American asylum law, a filing fee for the Form I-589, the application for asylum and withholding of removal. For the first time, people fleeing persecution, people who by definition often arrive with nothing, may face a fee requirement to seek legal protection in this country. That is not a political opinion. That is a structural change that immigration attorneys across the ideological spectrum have flagged as both unprecedented and legally contested. Here's what many people are misunderstanding. Many applicants assume that these fee increases only affect new applications filed after the effective date. But the timing implications are more nuanced than that. If you have a petition that you've been preparing, if you have an I-485 package sitting on your kitchen table waiting for one more document, if your attorney has been drafting your I-140 and the employer authorization is still pending, the clock is running because once USCIS begins accepting applications under the new fee schedule, any application received on or after that date must include the new fee. A check written for the old amount will result in rejection. Your entire package, I-485, supporting documents, photographs, medical exam, everything gets sent back. And in immigration, getting sent back is not a minor inconvenience. It can mean losing your priority date protections. It can mean refiling during a period of regulatory uncertainty. It can mean additional months of delays that affect your work authorization, your travel ability, and your family stability. Let me tell you about someone. Let's call her Maria. She's a 34-year-old registered nurse who came to the United States from the Philippines on an H-1B visa sponsored by a hospital system in Texas. Her employer filed an I-140 on her behalf 3 years ago, and it was approved. She's been waiting in the EB-3 backlog, a queue that for Filipino nationals in employment-based Category 3 stretches back more than a decade due to per-country annual caps under the INA. Her priority date recently became current. This is the moment she's been waiting for. Her attorney tells her in January of 2026 that she can finally file her I-485. But between gathering her medical exam results, coordinating with her employer's legal team, and waiting on a translation of a civil document from overseas, her filing package isn't ready until late April. She submits what she believes is the correct fee based on information she found online, but the information was outdated. She submitted the old fee amount. 3 weeks later, her entire I-485 package comes back rejected. Her priority date due to technical filing rules is now at risk. What should have been the most important filing of her immigration journey becomes a crisis caused entirely by a fee miscalculation during a transition period. Maria's situation is not hypothetical in spirit. Immigration attorneys across the country are right now counseling their clients about exactly this risk, and that's why this video matters. Now let's talk about the H-1B visa because this is another area where the fee impact is substantial. The Form I-129, the Petition for Non-Immigrant Worker, is the vehicle for H-1B sponsorship, L-1 transfers, Z-01 petitions, and other work visa categories. The fees associated with the I-129 are increasing, and for H-1B petitions specifically, Congress has in recent years layered on additional statutory fees, including the Asylum program fee, which under the new USCIS rule will be required of most employers filing H-1B petitions unless the employer qualifies as a small employer or a nonprofit. For large employers, defined under the rule as those with more than 25 full-time equivalent employees, this Asylum program fee alone adds $2,600 per H-1B petition on top of base filing fees, premium processing fees if elected, and any applicable fraud prevention and detection fees already required under existing law. For companies sponsoring dozens of H-1B workers annually, the aggregate fee burden increases by hundreds of thousands of dollars. And guess who often bears the indirect cost of that burden? The workers themselves through depressed compensation growth, slower promotion cycles, or employers who simply reduce their international hiring. But there's a serious catch you need to understand. The fee increases are not the only thing changing. The structure of who pays what and when is also being reformed. Under the new rule, USCIS is eliminating the separate biometrics fee for most benefit types and rolling it into the base application fee. That sounds like simplification, and in some ways it is. But for applicants who in the past were exempt from biometrics, certain elderly applicants, certain petition types, The practical effect may be paying more because the bundled fee doesn't distinguish their circumstances the way the old unbundled structure did. Immigration is always in the details. Always. Let me give you another example. Think about a man named Ahmed, a 47-year-old from Egypt who has been living in the United States for 11 years. He came on a student visa, overstayed, built a life, married a United States citizen, has 2 American-born children, and has been pursuing adjustment of status through his marriage. His wife filed the I-130 years ago, and the petition was approved. But Ahmed's case has complexities. A prior removal order that was administratively closed, a gap in work authorization, and his attorney has been carefully timing the I-485 filing to align with a favorable regulatory window. Ahmed's family cannot absorb a sudden, unexpected fee increase of several hundred without financial hardship. He's not wealthy. He works in food service. His wife works part-time while caring for their children. For families like Ahmed's, the fee increase isn't an abstraction. It's a rent payment. It's a car repair. It is money they have to find somewhere. This part could affect you even if you think it doesn't. Some of you watching this are not currently in the middle of an active immigration filing. Maybe you have a green card already. Maybe you're a naturalized citizen. But immigration fees affect you too because you may have family members abroad sponsoring petitions that your employer or family member needs to maintain. Because you may need to file a petition for a relative. Because the cost structure of the immigration system determines how accessible legal immigration pathways are. And when costs rise dramatically, some families choose illegal workarounds, predatory notarios, or simply give up on legal pathways altogether. The systemic impact of fee increases reaches far beyond the individual application. So now let's talk about what is actually being contested because this story is not entirely settled. Several immigration advocacy organizations and legal nonprofits have raised constitutional and statutory challenges to specific aspects of the new fee rule, particularly the asylum fee, which critics argue violates the spirit, if not the letter, of the 1951 Refugee Convention obligations the United States has incorporated through domestic law and potentially conflicts with statutory language in the INA itself regarding access to asylum proceedings. Federal courts have the authority, under the Administrative Procedure Act, to review agency rulemaking and set aside rules that are found to be arbitrary, capricious, contrary to constitutional right, or in excess of statutory authority. Whether litigation succeeds in delaying or enjoining any portion of the new fee rule remains to be seen. Federal district courts can issue preliminary injunctions which can delay implementation. Circuit courts can affirm or reverse, and ultimately the Supreme Court of the United States has the final word on questions of administrative law and regulatory authority. However, this protection is not permanent. Even if a court issues a temporary injunction halting part of the fee rule, injunctions can be lifted, stays can be reversed, and the underlying regulatory authority that allows USCIS to set fees through rulemaking is well established and has survived legal challenge before. You cannot plan your immigration strategy around the possibility of a court delaying these fees. You must plan as though the fees will take effect as scheduled and treat any litigation outcome as a potential benefit, not a guaranteed protection. So what should you do right now? Let's be specific. If you have any petition or application that is ready to file, or close to ready, and I mean close, prioritize getting it filed before the new fee effective date. Work with your attorney to identify what's missing, what can be expedited, and whether it's worth filing a complete package now versus waiting for one more document. In most cases, filing sooner with the current fee is the right strategic call if your case is otherwise ready. If you are in the process of gathering documents for a future filing, get organized now. Request civil documents, translations, medical exams, and employer authorizations as soon as possible. Immigration medical exams through USCIS designated civil surgeons can take weeks to schedule. Start that process today. If you are working with an immigration attorney, and if you are not, you should seriously consider it for any case of meaningful complexity. Make sure they are tracking the fee effective date and have already updated their fee intake procedures. Ask them directly, what is the new filing fee for my case type under the 2026 schedule? A good immigration attorney will have that answer immediately. If you are not currently working with an attorney and are considering filing pros on your own, understand that the margin for error just got smaller. A rejected filing due to an incorrect fee during a transition period could cost you more in delays than an attorney's retainer would have cost. The equation has changed. Do not rely on unofficial fee calculators, immigration forums, or well-meaning friends for fee information during a regulatory transition. The only authoritative source for current USCIS filing fees is the official USCIS website at uscis.gov and specifically the fee schedule published in connection with the final rule. Bookmark it. Reference it every single time before you prepare a payment. Be alert to immigration fraud and scams. Anytime there is a regulatory change of this significance, predatory actors enter the market. Notarios, unauthorized practitioners, and online services that promise guaranteed approvals or fee waivers they cannot legally provide will proliferate. If someone is charging you to explain government fees or promising to get you a discount on USCIS filing fees, that is a red flag. USCIS sets its own fees. No third party can reduce them if you believe you may qualify for a fee waiver, and USCIS does provide fee waivers for certain applicants who demonstrate financial hardship, primarily for humanitarian benefit types. Consult an attorney or accredited representative about whether you qualify. The Form I-912 is the request for fee waiver, but understand that the new rule has also modified the fee waiver eligibility framework, and not every category that previously qualified will continue to qualify in the same way. Finally, monitor USCIS announcements and the Federal Register for any updates related to implementation, litigation, or regulatory delays. If a court issues an injunction, USCIS will announce updated instructions. But do not wait for that. Plan for the fee increases to take effect on schedule. Let me step back for a moment and give you the broader picture. Because fees are not just administrative housekeeping. They are a reflection of something deeper about how the United States structures access to its immigration system. For decades, the policy debate about immigration funding has been caught between two irreconcilable tensions. On one side, the argument that USCIS must be self-funding through fees, meaning those who use the system pay for it. On the other side, the recognition that immigration is a public interest function, that the processing of asylum claims and humanitarian cases serves the national interest, and that funding an agency responsible for humanitarian protection creates an inherent conflict. Congress has periodically debated direct appropriations for USCIS funding the agency through the annual budget process rather than relying solely on fees. But that debate has never been resolved. What you're seeing now is the consequence of that unresolved tension. An agency forced to raise fees dramatically because it has been inadequately funded for years and is facing a caseload that shows no signs of shrinking. This is the structural reality of American immigration policy in 2026, and it is why staying informed not just about this fee increase but about everything that follows is so important, because the fee roll is not the only thing changing. The broader immigration policy environment is in motion across multiple dimensions simultaneously. Legislative proposals in Congress, executive actions, federal court litigation, agency staffing, and technology changes. And each of these moving parts affects processing times, fee adequacy, and ultimately whether your case moves forward or stagnates. The decisions you make in the next 60 to 90 days about whether to file, what to file, and how much to pay could have consequences that echo in your family's life for years. Immigration status is not an abstraction. It determines whether you can work legally, whether you can travel and return, whether you can bring your spouse or a child here, whether you can plan for a future in the country where you have built your life, raised your family, and contributed to your community. The stakes are not bureaucratic. They are deeply personal, and you deserve accurate, timely, trustworthy information to navigate them. If you want accurate, fast, and reliable immigration updates, subscribe to USA Move Guide right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential. If this video helped you understand what's coming with the 2026 USCIS fee increases, please give it a like. It helps this channel reach other people who need this information right now and don't yet know it exists. Leave a comment below and tell us your visa category or the type of petition you're working on. We read every comment, and your question may become the subject of our next analysis. And if you know someone in the middle of a green card process, an H-1B renewal, or a family petition, share this video with them today. Don't let them file the wrong fee amount because they didn't have the right information in time. That's what this channel is here to prevent.